Hi friends, hope you are doing well. In today's video, we'll discuss latest Supreme Court ruling in case of reassessment controversy. As you are aware that after Ashish Agrawal cases, there were multiple writs filed before the various high courts challenging the validity of the reopening on various counts. And many of the high courts gave their verdicts in favor of the SSC when quashed 148 AD orders and 148 notices. So agreed by this, department obviously filed writ before the Honorable Supreme Court, and after hearing both the parties, now Supreme Court came up with its final verdict. So let's get started. We'll see. Union of India versus Rajiv Bansal. So the verdict is given by none other than Honorable CJI of India, Dr. D.Y. Chandrachud. So verdict is divided into background, Income Tax Act, TOLA, Finance Act. Basically, it is interplay of all these three acts. Issues, submission, legal background regarding reading TOLA into the Income Tax Act. Section 148 notices issued between June to September, that is post Ashish Agrawal. Scope of 142, scope of Ashish Agrawal extended to all the reassessment notices issued between April to June 21. Effect of the legal fiction and conclusion. So what Supreme Court said, the present batch of appeals involves the interplay of three parliamentary statutes, that is Income Tax Act, Taxation and Other Laws, Relaxation and Amendment of Certain Provision Act, that is TOLA 2020, and the Finance Act 21. Income Tax Act was enacted by to levy and collect tax on income of SSC. Section 147 to 151 of the IT Act deal with the procedure of reassessment of the income chargeable to tax which has escaped the assessment. TOLA was enacted in background of the COVID-19 pandemic to provide relaxation of time limits specified under the provision of the Income Tax Act and certain other legislation as defined under the Section 21 of the TOLA. Finance Act 21 amended the provision of dealing with the reassessment procedure under the Income Tax Act with effect from 1st April 21. In Ashish Agrawal, this court was called upon to decide whether the revenue was correct in issuing the reassessment notices under the old regime when the new regime was beneficial to the SSC was already in force. This court resolved the issue by holding that all the reassessment notices issued after 1st April 21 should have been issued in accordance with the new regime. However, the court constructed the notices issued under 148 of the old regime by deeming them to be notices issued under 148B of the new regime. So, just to save those all 90,000 notices, Supreme Court decided to impose a deeming fiction by treating them the 148B notices. In Ashish Agrawal case, this court did not deal with the issue of whether or not the reassessment notices were issued within the time limits prescribed under the provision of the Income Tax Act read with the TOLA. This is the primary issue that comes for the consideration in the present batch of appeals. So this is the whole crux of the Supreme Court judgment, that the notice is issued is within time limit prescribed under the act read with the TOLA. So that was the grounds of appeal of the department, and that is dealt by the Supreme Court. The present batch of appeals give rise to the following issues: whether TOLA notification issued under it will also apply to reassessment notices issued after 1st April 21, and whether the reassessment notices issued under Section 148 of the new regime between July and September 22 are valid. If you can see in first ground here under, there seems some missing of the sentence that should be I think under old regime, because this sentence seems incomplete or incorrect. So basically, many high courts held that TOLA is not applicable under the new regime and notices issued after 1st April 21 are invalid. So let's see what Supreme Court has to say in this regard. So first let's go through the department submission. Parliament enacted TOLA as a freestanding legislation to provide relief and relaxation to both assessees and the revenue during the time of COVID-19. TOLA seeks to relax actions and proceedings that could not be completed or complied with in the original time limit specified under the Income Tax Act. Section 149 of the new regime provides three crucial benefits to the assessee. 4-year time limit for all situations has been reduced to 3 years, right? The first proviso to 149 ensure that the reassessment for the previous assessment years cannot be undertaken beyond 6 years. And the monetary threshold for the rupees 50 lakhs will apply to the reassessment for previous assessment years. Here it should be read as a more than 3 years. The relaxation provided under Section 3(1) of the TOLA apply notwithstanding anything contained in the specified act. Section 3(1) therefore overrides the time limit for issuing a notice under 148 read with the 149. Right. TOLA does not extend the life of the old regime. It merely provides a relaxation for the completion or compliance of the action following the procedure laid down under the new regime. The Finance Act 21 substituted the old regime for the reassessment with the new regime. The first proviso to 149 does not expressly bar the application of the TOLA. Section 3 of the TOLA applies to the entire Income Tax Act, including 149 and 151 of the new regime. Once the first proviso to 149 1b is read with the TOLA, then all the notices issued between 1st April 21 to 30th June 21 pertaining to the AY 1314 to 1718 will be within period of limitation as explained in the tabulation below. So this whole table can be considered as the crux of the submission made by the revenue, and this was finally upheld by the Supreme Court also. So first we'll see assessment at 1314 within 3 years, time barring on 31st March 2017. So obviously TOLA is not applicable at that time. Now read with the first proviso of the new regime of the 149. So within 6 years. So as you are aware that what first proviso to 149 says that no notices could be issued if such notices could not be issued during the old regime. So that's what within 6 years falls on 31st March 20, and read with the TOLA that time barring on 31st June 2021. And so goes with the 14, 15, 15, 16, 16, 17, 17, 18. So for 15, 16, department decided that reopening cannot be done at all. But for 16, 17 and 17, 18, TOLA will be applicable within 3 years limit. And for 13, 14 and 14, 15, TOLA will be applicable and if the escapement is more than 50 lakhs. Now we'll see arguments made on behalf of the assessee. TOLA applies only when the period of limitation expires between March 2020 and 31st March 21. Finance Act 21 was enacted after TOLA. Consequently, TOLA only held that the till the new regime came into effect from 21. Revenue had to issue 148 notices in terms of the new regime without recourse to extended time limits under TOLA. TOLA did not amend the erstwhile Section 149 but merely extended the specific time limits. The first proviso to 149 1b only refers to the period of limitation under the erstwhile 149 1b. Notification number 38 of the 21 was issued on 27th of April 2021 to extend the time limits expiring under 149 1b of the old regime until 31st June 21. The notification issued after 1st April 21 when the old regime was repealed and substituted by a new regime. Therefore, this notification cannot be read into the new regime. The notices can be categorized into following 4 categories. First category for assessment year 13-14 and 14-15, the 6 years time limit in terms of 149 expired on 31st March 20 and 21 respectively. However, reassessment notices were issued after 21 and would be barred by the limitation. Second category for the EY 1516, issue pertains to whether sanction of the appropriate authority was obtained by the AO before issuing reassessment notices under 148 of the new regime. For this category, 4 years period expired on 31st March 20. However, notice is issued under section for this category. However, notices were issued after 31st March 20 by obtaining section under 151.2 instead of 151 of the old regime. Third category 1617 and 1718 3-year period is in terms of amended regime expired on 31st March 20 and 21 respectively. Notices issued under 148 were issued after expiry of the 3 years, that is after 1st April 21. However, sanctions were obtained under 151.1 instead of 152 clause 2 of the new regime. And directions issued by this court, Ashish Agrawal, were not intended to apply to SSC who did not challenge the reassessment notices before the High Courts or this court. Therefore, reassessment proceedings could not have been initiated for such SSCs. Now we will see the conclusion of the Supreme Court. Actually, this judgment runs into one total of 112 pages. So we will not go into detail, otherwise the video will never end. We'll see what the ratio have done by the Supreme Court. In view of the above discussion, we conclude that after 1st April 21, the income tax has to be read along with the substituted provision. First, that is, new regime will be applicable. Second, TOLA will continue to apply to Income Tax Act after 1st April 21 if any action or proceeding specified under the substituted provisions of the Income Tax Act fall for the completion between 20th March 20 and 31st March 21. C. Section 3(1) of the TOLA overrides Section 149 of the Income Tax Act only to the extent of the relaxing the time limit for issuance of the reassessment notices under 148. And D. TOLA will extend the time limit for grant of section by authority specified under 151. The test to determine whether TOLA will apply to 151 of the new regime is this: if the time limit of 3 years from the end of the assessment year falls between 20th March 20 and 31st March 21, then specified authority under section 151(1) has extended time till 30th June 21 to grant approval. In case of section 151 of the old regime, the test is if the time limit of the 4 years from the end of the assessment years falls between 20th March 20 and 31st March 21, then specified authority under section 151(2) has extended time limit till 31st March 21 to grant approval. The directions in Ashish Agrawal will extend to all 90,000 reassessment notices issued during the old regime. The time during which the show cause notices were deemed to be stayed is from the date of issuance of the deemed notice between 1st April 21 and 30th June 21 till the supply of the relevant information and material by the AO to SSC in terms of the direction issued by this court in Ashish Agrawal and the period of 2 weeks allowed to SSC to respond to show cause notices. The AO are required to issue the reassessment notices under 148 of the new regime within the time limit surviving under the IT Act with the TOLA. All notices issued beyond the surviving periods are time barred and liable to set aside. The judgments of the High Courts rendered in various cases before various High Courts and other judgments of the High Courts which are relied on this judgment are set aside to the extent of the observation made in this judgment, and the appeals filed by the revenue are accordingly allowed. Appeals filed by the SSC will be governed by the reasons discussed in this judgment. So this is the crux and conclusion drawn by the Supreme Court, and Supreme Court upheld the TOLA is applicable after 1st April 2021. But after 1st April 2021, department was supposed to issue notice under new regime within the time limit prescribed in the new regime read with the TOLA. So as we have discussed earlier, So this table aptly summarizes the whole Supreme Court judgment, provided AO is taken prior approval of the appropriate authority before issuing notices under the new regime. Also, this judgment is not applicable to pan India, though any judgment of the Supreme Court eventually becomes law of land. And also, in case of Hexaver Technologies and various other judgments where reassessment held invalid on count of that lack of jurisdiction, notice is issued by the JAO instead of NFSC. So those issues are still open. So let's see what will happen to those issues and for those cases in which case the appeals are pending before CIT appeal. आई होप ये वीडियो आपको पसंद आई होगी. थैंक्स फॉर वॉचिंग दिस वीडियो. हैव अ गुड डे.